appeal in the matter of ABN, AMRO Bank LP, and Rodeo and Son Clients Insurance PLC and others.
My lords and
Mr. Eggers, just hang on a second, please. I'm afraid I've not had my clerk has unfortunately got COVID. It appears that therefore the setup that usually appears seamlessly has not taken place. So I just need to get myself sorted out.
Very good, my lord.
It should be clear, please, to everyone that we accept transcript writers in this court, provided they are ready at 10:30. We do not allow breaks for transcript writers or delay to the court proceedings for transcript writers to get themselves set up. Otherwise, we'd never do anything at all here. Just to be clear. Right, we're cooking with gas.
Excellent, my lord.
Mr. Eggers, I wasn't expecting to hear from you first, but is that what's agreed between the parties?
It is, my lord.
Okay.
So there, my lord, well, allow me to introduce the parties first, if I may.
Yes.
I appear together with William Mitchell on behalf of the insurers, both the appellant insurers and the respondent insurers, bearing in mind there are two appeals. My learned friends, Ms. Rebecca Savin, Claire QC, and Ben Parker appear on behalf of ABN AMRO, who were the bank, the insured under the relevant policy. And my learned friends, Ms. Siobhan Healy, QC, and Mr. Harry Wright appear on behalf of the broker, Edge. My lords and my lady, you should have a timetable which has been agreed between the parties.
No.
I will make sure you have one as soon as I can. I can at least hand up
Well, just tell me what it is.
I beg pardon, my lord?
Just tell me what it is.
It's the timetable is, my lord, there are two appeals. I will refer to one as a TPC appeal, which is concerned with construction of the TPC clause. The other one is the estoppel appeal.
Yep.
The TPC appeal, where I am the appellant on behalf of all insurers except for two, is basically to take up today's proceeding.
Today?
Today.
Extraordinary. Extraordinary, Mr. Eggers. I would have thought 2 hours maximum.
Well, there's
I mean,
lots.
the issues in this case that are, if difficult, are the estoppel issues. But anyway, if that's what you've agreed, we'll be rising very early this afternoon.
Well, I'm having earned that reaction, my lord. I'm sort of hesitant to say the next bit because even though today the TPC appeal will take today and will eat into about half an hour of tomorrow.
I do not think so, Mr. Eggers. That
Oh,
would be a waste of our time. Yes. Next. What
Well,
else is agreed?
my lord, and then of course the rest of the time will be taken up with the estoppel appeal. But of course we can recalibrate that as my lord and my lady wish.
We've read everything,
I know you do.
Mr. Eggers. We're very much on top of this case. I would have thought that the TPC appeal should take 2 hours in total, with arguments on both sides. I could be persuaded that 3 o'clock today would be an absolute maximum. But the estoppel appeal, I can see, could take a little time. It's maybe some cases to look at.
My lord, I do have a number of things to say about the TPC.
Okay, well, you fire away then, and off we go.
Very good, my lord. Well, I'll put the timetable away
But I'd like to see it.
now.
Yes.
Yes.
You haven't seen it.
I've 3 copies here, I think.
I can't believe that we haven't been shown it in advance.
I beg your pardon, my lord?
I can't believe we haven't been shown it in advance, Mr. Eggers.
I assumed you had. I assumed it had been provided. But all I know is it had been provided to the court.
And for future reference, I don't look at paper and I require everything to be sent electronically.
Well, I think it was originally.
No, it wasn't.
Okay, my lord.
Thank you.
Right.
Well, if I may then move on to the appeals.
Yes.
The TPC appeal, my lord. As I say, I represent all but two of the insurers in relation to the TPC appeal. The estoppel appeal, of course, is a separate appeal. And the respondents to that appeal are, of course, ABN AMRO in one sense, but also two of my clients, which are Ark and Advent, two of the insurers. They also raise in their respondent's notice an additional estoppel by representation point, but also rely upon the TPC construction issue as well. So as far as the TPC appeal is concerned, that will, if you like, also deal with one of the respondent notice points raised by Ark and Advent. The same arguments. My lords, you should, just to confirm, you should have 5 electronic bundles.
We've got lots of bundles. Thank you.
I'm happy to stock take if you wish. If not,
there's no need to stock take. If we get to a bundle we haven't got, we'll let you know about it.
There is also an issue about supplementary skeletons raised, served by...
There's no issue. We've looked at them. They're there for what they're worth.
Yes, but there is... Yes, my lord. It was received by the court on a de bene esse basis.
Yes.
There is an objection raised by my clients in relation to certain paragraphs of Edge's supplementary skeleton, which I suggest be dealt with before the estoppel appeal begins.
No. It'll be dealt with as part of the estoppel appeal when we get to the estoppel appeal. If
Right.
you're going to open your underwriter's submissions on your own appeal, I suggest you do it.
I'll do it now.
Thank you.
My lords, the issue before the court concerning the construction of the TPC, the Transaction Premium Clause, is a shortly stated one.
Is a...
Shortly stated.
Yes,
issue.
very shortly stated, Mr. Eggers, I agree.
Does the TPC clause cover pure economic loss in the form of a trade credit loss, which is not dependent on physical loss or damage? Or does it extend cover for an anticipated profit only in the event of physical loss or damage to the goods, where the bank's client defaults under the repo, the repossession transaction, and there is a resale? Now, my lord, I will keep referring to the bank, which is a reference to ABN AMRO. In fact, one of the vehicles used for these transactions was iStar, but just for the sake of convenience, I'll refer to the bank. In this case, the bank advanced funding to its clients, two companies, Transmar and Euromar, who transferred title to Coco to the bank at a discounted price. The intention was the bank would retransfer title to its clients at a higher pre-agreed price in the event of default. But in the event of default, it is alleged by the bank that there is cover under the TPC clause, and I'll come back to that in a moment. Now, what had happened in this particular case, my lords, is that Transmar and my lady, Transmar and Euromar defaulted and did not repurchase the Coco by reason of their own financial collapse. There was no physical loss or damage. The question arises how a loss might arise in these circumstances, bearing in mind that the bank could sell or resell at the market price. And the reason given is that the goods themselves were not of sound quality. Because they were of poor quality, the bank could not realize their full price on resale. Therefore, in this case, there was a default by the bank's clients and there was a trade credit loss, and no physical loss or damage. And the judge below, the learned judge below, held that this loss was recoverable under the TPC. The judge, however, was wrong in this decision. Now, my lords, and my lady, I'm going to address my appeal under 6 headings. The first are the principles of interpretation, which I'll deal with reasonably briefly. The second is the factual matrix. The third is the nature of cargo insurance and the subject matter of a cargo insurance. The fourth is the policy as a whole. The fifth is the language of the TPC itself and its purpose. And then the sixth, I'll look at certain other specific provisions of the policy and see how they impact construction. So they're the 6 headings. So I begin, my lords and my lady, with the principles of interpretation. And
There's no controversy about them, is there?
I don't believe so, my lady.
So why do we need to hear about it?
Well, all I would ask you to recall is this, that what we are engaged in is an exercise of interpreting the language in the relevant context. I don't think that anyone disagrees with that. And that can be approached in either looking at the language first or looking at the context first. And then it's an iterative process, so you go through the whole exercise and you come up with a solution. The only thing I would make clear is there have been references, for example, to Lord Clarke's statement in Rainy Sky, where the language is unambiguous. It must be applied, and I don't quarrel with that. However, what that has to be understood as the ambiguity or the lack of ambiguity, the unambiguous nature of the language, only exists not when you're looking at the superficial meaning of the words used, but when you look at the words used in context. So it's only after you go through this iterative process of construction that you end up with a meaning which is either unambiguous, or you end up with more than one meaning, which is ambiguous.
Do you say the clause is ambiguous?
Sorry?
Do you say the clause is ambiguous?
I do not.
Thank you.
So all I'm saying is that this clause, when construed in context, has one meaning and one meaning alone.
In this case, these cases on construction have taken up weeks of these courts' time, and this court is completely familiar with the authorities on
I don't
construction
doubt it.
and has delivered literally dozens of judgments about them. And so I don't think we're going to take very long reading Rainy Sky again, or Lord Hodge, or any of the other cases, unless you've got a point to take out.
No, I think that's, and I'm not surprised by what my lord says.
Good.
So that brings me to the second topic, which is factual matrix. Now, the judge made a number of findings below, which the ones we rely upon, if you like, are the ones which are referred to at paragraph 14 of our skeleton argument. And the court's reference, that's page, the core bundle, tab 19, page 505 to 506.
14 of your skeleton.
Paragraph 14, yes. Page 505 of the bundle. Tab 19. Now, I'm not going to read out these points. I'll just summarize them very briefly, but they're there for the court's reference. What is important? This is a cargo insurance, and the provision of trade credit insurance in the cargo insurance market, which is the marine market, is unprecedented, particularly a policy of this type. Trade credit insurance is a wholly different nature of insurance, has different types and levels of risk, and it's dependent on commercial default, not on loss of or damage to property. The judge also indicated that there was no expertise of underwriters, particularly in the cargo market, with respect to writing trade credit insurance. There was no due diligence undertaken by the bank to ascertain quality of the cargo. It was found that the clause was drafted by ABN's, the bank's lawyers. Now, my lords, even if the clause is carefully drafted, the policy as a whole, I suggest, is not once we look at it. There is no additional premium charged for this particular cover.
So what does that mean? The policy is not carefully drafted?
Well, one of the considerations which the the Supreme Court has indicated in the trio of cases is the quality of drafting. But the other factor, my
So
lord,
you make a rather glib throwaway line. This is not a carefully drafted policy. I mean, what you mean is, if you're making that submission at all, that inserting the TPC into a cargo policy creates, what should we say, tension.
it does, my lord.
But it's nonsense to say the policy is not carefully drafted. Of course it is.
Well, my lord, I think the other thing to bear in mind about slips or a slip policy used in the insurance market, particularly of this nature, is that unlike, for example, banking transactions, which are very much longer, these are often compressed documents which incorporate provisions from standard market wordings, and they are agreed over time, often in a compressed atmosphere. But the reason slips have to be looked at in a particular way when one construes them is because they are brief documents compared to other commercial documents. And I'm not saying that my appeal hinges on that consideration at all, but it's a factor which the court should be aware of. So, my lord, in this particular case, the judge had found that the TPC insured against pure economic or financial loss, even in the absence of physical loss or damage to cargo or goods. Now, bearing in mind that cargo insurance is very generally, if not universally, dependent on insuring against physical loss or damage, with occasional supplementary covers, I accept. To find a trade credit insurance provision in a cargo insurance policy of this nature is like someone going to a car dealership and asking to buy a yacht. It's an entirely different type of product. Now, my learned friend, Ms. Savinclair...
So you're saying that if you go into a car dealer and contract to buy a yacht, you won't have contracted to buy a yacht?
No, but if I use a name, like I'll provide a name which are real-life examples of a designer, a yacht which is designed by a car maker, and I use, let's say, X, I won't say what, and it goes, and I go in, I'm actually intending to buy a yacht, but objectively, what I'm really getting is a car. So it's the same with trade and credit insurance. If you're going to go to trade credit insurance, you go to the trade credit insurance market. You don't go to the cargo insurance market.
Well, they did.
Well, my lord, that presupposes the question whether or not it's a trade credit insurance clause, and that's an issue I'll come back to.
Why aren't you starting with the clause if you're saying it's
because I want, my lord,
trade credit insurance?
My lord, as the Supreme Court has said on a number of occasions now, it doesn't matter where you start, whether it's with the clause or with the context. And I'm choosing to start with the context, if I may. But I'll start with the clause if my lord wishes. It's up to you.
Well, you take your own course, Mr. Eggs, but you have got to persuade us that the clause doesn't mean what it says. I mean, to say, as you do in paragraph 15 of your skeleton, the judge erroneously decided that the above factual matrix was not sufficient to displace what he considered to be the ordinary meaning of the words used in the TPC is quite a strong, if not remarkable, submission. I mean, if the words mean what they mean, and you've said they're not ambiguous, then you're dead unless you can persuade us that the words meant something else.
Well,
I wonder why one doesn't start with the words.
My lord, I will, if I may, I'll continue in the course I've decided.
Of course.
But my lord, I'll come back to the wording, and I'll make submissions on that. I'm not going to address it now because I'm going to look first at the question of. I've raised issues of factual matrix.
Well, the judge accepted, did he not, that the starting point is that you wouldn't expect a clause of this type to appear in a policy of this type.
Correct.
If you're placing marine cargo insurance, you would normally expect to be insuring against loss or damage to cargo. But that is not an inevitability because, as you rightly accept, there may be add-on clauses which are not dependent on physical loss or damage.
But
The question is whether this is one of them.
Yes, my lord, but when I say add-on or supplementary clauses, what I'm really referring to, and I'll go through it as I go through the policy, but what they really are engaged with, for example, you might find what's called a forwarding expenses clause.
Yeah.
So that, in a sense, that's all. The cargo is not in bad condition, it's not damaged, it's not lost, but it has to get to the destination, and often a cargo insurer will pick up those expenses. Now, the reason that's important is because in the cargo insurance world and the cargo insurance law, one of the losses which can occur is called the total loss of the adventure. And the adventure is, of course, the movement of goods from A to B. And if it doesn't get to the destination, there will be a total loss of the adventure. And that's why forwarding expenses are covered as a pure economic loss. But that's entirely supplementary to the main physical loss or damage cover. When we talk about trade credit insurance, that's an entirely different nature.
But it's all very interesting, Mr. Eggers, to go into every clause in a cargo policy and look at why they're there and why they're normally there. This is not a normal situation. This is a situation where the bank drafted a clause and said, this is the insurance I want, which is of a special kind, not saying what kind, and the underwriters agree. So unless you persuade us that it doesn't do what the bank thought it did and what the judge thought it did, your appeal, however much we look into the great history of cargo policies, is dead. I mean, you know, I know how important everybody thinks this case is, but it's a question of showing the judge was wrong. And we cannot go into the history of cargo underwriting to do that. We have to look at the words of the policy and see if the policy means what the judge said or not. Because it's unambiguous, you agree?
Well, as I say, it's unambiguous. After one goes through the whole process of construction, you end up with an interpretation which is that it does require physical loss or damage before the TPC clause will respond.
Well, I mean, we've read your skeleton argument.
Very good, my lord.
And we remain, as you can already see, somewhat sceptical.
But if I may develop my submissions.
Yes.
I mean, my lord, and I promise you, I will come to the TPC wording.
Good.
But if I may, let me start then. I've dealt with the first two issues briefly. Let me deal with the nature of a cargo marine insurance and the subject matter of insurance. And this is important, my lord. And one has to look at the policy for this purpose. Before I do, what I will take you to is a few authorities to address this issue. The first. So if you've got you should have two authorities bundles, one for the TPC appeal and one for the estoppel appeal. It's obviously the TPC authorities bundle I'll be taking you to.
And were they on separate PDFs?
Yes, they are. Yes, there's two numbers, my lord. This is 0739.
May have been a casualty of my clerk.
Would it help if we resubmitted it, Mike?
It would be a help if somebody could. Let me just see if I can find it. I'm 0671. I got.
That's the estoppel appeal.
I was conscious of not having got the other one. I only got 0671, not 0739. Maybe my JA could send it to me. He may be able to send it to me quite quickly. What are you looking at? Which case?
Well, I was going to glance at, if I may, Engelhardt, which is the
Egghart.
Engelhardt,
Engelhardt, yes.
which I know my lord's looking it up elsewhere, so I can.
Yes, I can find it. If you just tell me the spelling of Engelhardt.
Well, it says ENGELHART.
Versus. And what's the neutral reference?
It's 2018 EWHC 900.
My lord, I have an electronic copy I could email to you if that would assist. If someone would write down an email address, then I can send it to you directly.
Perhaps I can just ask my JA whether he's going to be able to eat. He sent it, so maybe we're okay. Yeah, I've got Engelhardt. I've got Engelhardt, and hopefully I'll have the entire bundle in just a second. Good.
I'm just asking my lord and my lady have that Engelhardt. Yes, very good. So now the proposition for which this stands is actually not a controversial proposition because both the judge below and also all the parties accept it. And I'll explain what that is in a moment. And I will only spend a couple of minutes on this case.
Well, and what is the proposition?
The proposition is, you can see it, paragraph 40 on page 211 of the bundle.
Yeah.
Beginning of paragraph 40, having discussed the nature of cargo insurance, the learned judge says, since an all-risk marine cargo policy is generally construed as covering any losses flowing from physical loss or damage to goods, there must be clear words indicating a broader intention. So, and the judge adopted the same approach below, my lord. So now, what happened in this particular case, and there's a reason I'm bringing your lordships to it and ladyship to it now, is that it's relevant later on. And the thing to note about this case is this was the case where goods, my lords and my ladies.
It didn't exist. It was a case where there was a fraudulent documents clause, and the goods couldn't be shipped because they never existed in the first place. And the question is whether it covered that or not.
Correct, ma'am. Perfectly.
And the judge found that it didn't because the overall intention was that it should cover physical loss and damage. And in any event, the fraudulent documents clause actually says, in terms, this insurance contract covers physical loss or damage to goods.
Very good.
It very much turns on the facts and circumstances of the particular clause.
And of course, all the cases, and I'm not going to take the court to many cases, but the cases I take you to all turn on their facts. But they do also stand for certain principles. And in this particular case, it is worth noting, for example, at paragraph 11, which is at page 206, how the subject matter of the insurance, which is identified in the interest clause, is defined. Similarly, you will have a basis evaluation clause and also identification of the institute cargo clauses, which are all physical loss or damage clauses. Now, I can put that away, but what I do want to take the court to now, if I may, is tab 1 of this bundle, which is the Marine Insurance Act. Now, there are just 3 sections I want to take you to very briefly. The first is section 3, which is page 1 of the bundle. Now, section 1 defines a marine insurance policy or contract as one where the insurer indemnifies against marine losses. So it's a contract of indemnity. And marine losses is defined to mean losses incident to the marine adventure. Now, the marine adventure is defined at section 3 of the Act. And it says at the bottom of the page, in particular, there's a marine adventure where, and then it has 3 examples, A, B, and C, or 3 items, A, B, and C. The first one is often regarded as being property insurance. The second one is financial loss insurance, which will cover loss of profits. And the third is liability insurance. They're the three main types of insurance. The first one defines the insurable property, which is ship, and for our purposes, goods. And it's in a property insurance is where the goods are exposed to maritime perils. Maritime perils is expansively defined at the end of the section. But B is relevant because there, the marine adventure is the earning or acquisition of any freight, passage, money, commission, profit, or other pecuniary benefit, or security for any advances, loan, or disbursements where endangered by the exposure of insurable property to maritime perils. So in the marine adventurers, for the purposes of a marine insurance policy, in the context of financial loss, arises where the property is exposed to maritime perils. So it's not a pure financial loss, it's where you have the property being exposed to maritime perils. And that's also reflected in section 5.2, which defines an insurable interest. And I'll come back, I raise it now because I can come back to it later without having to take you to the authorities bundle. A person is interested in a marine adventure where he stands in any legal or equitable relation.
Which section?
Section 5, subsection 2, my lord. To the adventure or to any insurable property at risk therein, in consequence of which he may benefit by the safety or due arrival of insurable property, or may be prejudiced by its loss, or by damage thereto, or by the detention thereof, or may incur a liability in respect thereof. Now, the important provision as well, which I do want to take you to, is on the next page, which is at section 26. In a marine policy, the subject matter insured must be designated in a marine policy with reasonable certainty. And then the section goes on the next page, which is really concerned with the nature of the insured's interest in the subject matter, which shouldn't concern us for the time being. Now, the requirement of the subject matter of the insurance being designated with reasonable certainty is an important one. It's a requirement of any marine insurance policy. And it's a distinct requirement from the principle in Engelhardt. Engelhardt was concerned with whether or not a cargo insurance policy extended to losses other than physical property losses, physical loss or damage. But what Section 26 requires, firstly, the policy to identify the subject matter, and not only to identify it, but also to designate it with reasonable certainty. Requirement of the policy.
So was this a marine insurance policy within section 1?
It is, my lord.
All of it.
All of it.
Why?
Because, firstly, it's an indemnity policy, so it insures against losses. Secondly, as far as the perils are concerned, maritime perils are defined to refer to things like perils of the sea, piracy, etc., but also perils designated by the policy. So it's quite an expansive definition.
The loss is incident to marine adventure.
Correct.
So that's a very general phrase.
It's defined in a very particular way, my lord.
Loss is incident to.
But marine adventure.
No, I understand marine
Yes.
adventure. You've shown us. Loss is incident to.
It has to be marine adventure, yes.
Very broad.
But the marine adventure is the exposure of insurable property, which gives rise either to property loss, financial loss, or liability.
I mean, are you saying really that this act prevents the parties contracting for marine insurance and another kind of insurance in the same policy? That it's
No.
thereby in some way unlawful?
My lord, no, my lord, I'm not saying that. This is an exercise in construction, nothing more. But the reason it's important is because the policy has to identify the subject matter. And I'm going to take
Sorry,
all
say that again.
the policy has to identify the subject matter of the insurance.
Well, of course.
And I want to develop that submission. It's an important submission, so I'm going to develop it now, if I may. And the first thing I'd like to say is that if we could take up the authorities bundle again, And the position's briefly summarized by the editors of Arnold, which you'll see at tab 15 of the authorities bundle. At paragraph 10.25, which is page 244. And what the learned editors say is the profits and commissions to arise from the sale of goods are really an interest in the goods themselves. And in one sense, an insurance on them is an insurance on goods. It's, however, well established that such profits or commission are not covered by a policy on goods. They must be specifically named. The rule is absolute in England. Now, this is a chapter which is concerned with the subject's marine insurance, but this principle is considered at more length in two cases I'd like to take you to. The first is a decision of the Privy Council in Morris against Goldborough Moor, which is at tab 2 of this bundle. And this was an appeal from the High Court of Australia. And in this particular case, what had happened is that there was wool in the physical custody, or bailment, if you like, of the wool brokers in a warehouse. And it had been consigned to them by the owners, or the growers of the wool. Now, the brokers, not the owners, but the brokers took out an insurance policy on the wool. And there was a fire which caused loss of or damage to the wool itself. And what happened was the brokers recovered under the policy, and they then had, under the law is, a bailee such as that can recover and insure for the full value of the goods, but then has to account to the true owner for the insurance proceeds. And but in the process, it's allowed to deduct from the proceeds any proceeds related to its own personal loss. And the personal loss, which was said to have been borne by the broker in this case, is their loss of commission or profits on the wool because they've been destroyed. And the issue is whether or not they could have done that, whether or not they were permitted to deduct that sum from the insurance proceeds, which they had to account to the owner. And so with that introduction, if I could just take you to page 460 of the report, and it's page 19 of the bundle. And I'm going to pick it up just, it's about a third, in the first paragraph on the page, just at the last sentence, begins the issue in. The issue in the action was as to the deductions which the respondents, the brokers, were entitled to make from the insurance proceeds in settling with the appellant, they're the owners of the wool. And I think we can then pick it up towards the bottom of the page, about 10 lines up from the bottom, where it begins, it is necessary. It is necessary, however, in examining the policy to distinguish between the subject matter, which is insured, and the insured's interest in the subject matter. The subject matter for the purposes of the present policy is the merchandise. That is the wool, which is insured against the risk of physical loss or damage by fire. But while the subject matter of the insurance is the chattel, the basis of the insurance is that the assured stands in such relation to the chattel that he may be prejudiced by its loss or damage in accordance with the various principles which have been settled for regulating what constitutes an insurable interest. And my lords and my lady may remember they're the terms of section 5 of the Marine Insurance Act. Going on to the next page, the subject matter of an insurance must be properly described. Thus, if the subject matter is a ship, the policy must so describe it. And conversely, if it's freight which is insured, that must be so described as the subject matter of insurance. So, of course, freight is profit as opposed to, or revenue as opposed to property. Similarly, by English law at least, an insurance described as an insurance on goods does not cover profits. And then I can pick it up, I'll just skip over the quote from Lucina and Crawford, and about towards about 15 lines from the bottom, it begins, in the policy here in question, the subject matter is described as merchandise, and the condition quoted above specifically states that the insured value is not to include profits of any kind. Hence, it is the wool, not any profits, which the policy insures. But the policy also describes the interest of the assured, which is covered as being the assured's own property in the wool, and also wool held by the respondents in trust or on commission, which they may be liable in the event of loss or damage by fire while lying in the specified stores.
I don't see with respect how this helps us at all, because all that's saying is if you've got a policy which insures against loss or damage to the goods, if you want to claim profits as well, you've got to have a clause which spells out that profits are recoverable under the policy.
No, there's more than that, my lady, if I may. What it's saying is the subject matter of the insurance must be identified and properly described. That's what it says.
Yes, but this was a policy where the subject matter was described as merchandise.
It is. That means property, not profits.
Understand? That's what my lady's just said.
Oh,
And if you want to insure against profit, you have to say so.
Yes, very good. And
What's that got to do with this case?
when I come to the policy, hopefully everything will become clear. But I just want to just set the groundwork by looking at the second authority now, which deals with this issue, if I may. I mean, if you want me to take a different course, I will. And I appreciate it.
You take your own course, Mr. Eggers.
Okay, but I don't want to.
Appropriate,
I beg your pardon, my lord.
but make it reasonably speedy, because at the moment, neither my lady nor I, we don't know about my lord, finding much help from these authorities.
Well, let me just take one more authority, but I'll take it more briefly rather than just to accommodate my lord. The second authority is the Frio Chili, which is tab 5. And in this particular case, you can see in the decision of Mr. Justice Coleman, and in this case, the interest was identified, and you can see in the head note, is frozen and or chilled meat and offal and frozen and or non-frozen dairy products. And there were a number of sections in the policy, which was, and one of those sections was section 2, which provided cover for EEC subsidies. And the issue arose whether or not, and you can see actually just before the holding in the head note in the second column, the issues described. The issue between the parties was whether the subject matter of the insurance provided under section 2 in respect of non-payment of the EEC subsidy was the goods to which the subsidy was attributable as the defendants contended, or the subsidy itself as the plaintiffs argued. So here you can see, and you probably get a better feel for it if I get to page 53 of the report.
The subsidy clause specifically said in this case that you only get cover for the subsidy in the event that the non-payment is due to a peril covered by the standard form of marine policy. So unsurprisingly, Mr. Justice Coleman held that you had to have a peril insured and approximate causation between the two before you could claim the loss of the EC subsidy.
Yeah, well, actually, my lady, I think he came to, his reasoning was twofold. The first reason was, which you referred to, which is the perils insured against identified in the subsidy clause, or subsidy section, were perils identified by reference to the institute clauses. So your summary, if I may, is correct. But the second reason was that the subject matter identified was not the subsidy, but instead the goods. And you can see, my lady, on page 53 of the report, that you have a number of sections. And there are 5 sections in the policy. Section 1, and I'm looking at the middle of the first column, identifies the main cargo insurance section, and it identifies the interest. And it's the words which I read out earlier in the head And then you have sections 2, 3, 4, and 5. Now, 3, 4, and 5 each use the word interest to identify the subject matter. But 2, which is a subsidy clause, does not. And for him, sorry, when I say him, his lordship, Mr. Justice Coleman at page 186, he says, this is the second column in the middle of the page. This is a section of some complexity. It contains no side heading interest. It follows unless it includes words which on their proper construction define the subject matter of the insurance cover provided by the section. The definition of the subject matter under the side heading interest in the opening words must be read into section 2. And the opening words, of course, refer to the meat and the dairy products as opposed to anything else.
So it turns on the construction of the clause in question, whether on its proper construction it defines the subject matter of the insurance cover.
Correct.
If it doesn't, you add the word interest in, which is roughly what Mr. Justice Coleman said at the bottom of page 52, page 184. Right-hand column. It's a matter of construction in each case, whether that which is insured is the goods on which the profits will accrue or the anticipated profits themselves.
Correct. And I accept that, my lady. It's always a question of construction. So, my lady, I think and you can see in the same page where Mr. Justice Coleman, at the bottom of the first column and the top of the second column, identifies 2 different ways you can insure profits. Yeah. One is where you insure the property, but you include within the value of the property profit element. But you still need physical loss or damage of the property to cover that. Or you insure profits by themselves. Very good, my lady. So that's... then I'm going to move on, if I may, to the policy itself. So with much prefiguring, I now turn to the policy. And that, my lords and my ladies, the core bundle, tab 10. Page 360. So this is a policy which has an opening section and 5 numbered sections, which follow. It is now, as we go through the policy, what I'm really going to be asking the court to identify is what is the subject matter of the insurance, how is it described, and how are the words subject matter insured used throughout, and also focus on the extent to which physical loss or damage is a requirement or a concept which lies behind the relevant provisions. Now, the opening section begins by using the words type, and you can see already it says marine cargo and storage insurance. The insureds are identified as ABN AMRO Bank NV iStar, which is the ABN AMRO vehicle. C identifies ABN AMRO Clearing Bank, but only when ABN AMRO Clearing Bank is owner of the subject matter insured, as such term is defined in section 1 condition, subject matter insured below. And then you'll see under the period clause on the same page, it refers to an open cover to accept all business declared during a 1-year period of time.
Sorry, where are you?
This is page 360, my lord. There's a period is on the left. Yes. Yeah. So this is essentially what's called an open cover. So you need a declaration. When it says a cover to accept all business, what would happen is that the insureds will lodge a declaration identifying the cargo consignments or the goods which are insured by the policy. You'll see the definition on the next page, 361, the word interest. So this is the word which was used, for example, in Engelhart and also in Frio, Chile. and interest begins all goods or merchandise appertaining to the insured's business for which the insured is the legal owner or for which the insured is at risk or responsible, contractually or otherwise, consisting of, and we have three different types of commodities: hard commodities, soft commodities, which includes cocoa, and energy commodities. So they're all items of property. The limits, which are referred to at page 362, are limits in relation to the interests A, B, and C as defined. There's a basis evaluation clause, which I'll come back to, because I'll look at the TPC clause before I come back to the basis evaluation clause. And anyway, it's repeated later on. Now, you will see at page 363, it has transit limits, which is worldwide. General conditions applicable to all sections of this contract. Notwithstanding anything contained herein to the contrary, it is agreed and understood in general terms that it is the intention of the contract to protect the interest of the insured at all times and in all circumstances. The contract is to protect against all risks of physical loss of or damage to the subject matter insured from whatsoever cause arising. So again, we have an express reference to the interest of the insured, which is clearly interest of the insured in the subject matter insured. The subject matter insured I'll come back to when it's defined, but what I will tell you is the word interest, which is in the opening section, which refers to the three types of commodity, is the subject matter, and it's often the word used to identify the subject matter. And then it says all other conditions are more fully detailed in each respective section and or as may be agreed with the underwriters only. And then you've reference to certificates of insurance, which are perfectly administrative, and then you have institute clauses, which of course really provide cover for loss or damage. And then at 364 on the next page, you'll see the reference to declarations having been made. So monthly declarations of amounts at risk, including seller insurance. And seller insurance is, again, physical loss or damage insurance. And it's a monthly declaration. So we're going to page 365. The heading of this is halfway down the page. Section 1, conditions, subject matter insured. Then it goes below that, subject matter insured, the interest. The interest is defined already in the opening section as the commodities. It's also cross-referred to when in the insured provision, when it referred to the definition of the subject matter insured. This is the only definition of the subject matter insured. There is no other definition. And then we can go to the next page, 366. This is all section 1. Then we have the word limit, which we've already seen because it's been repeated from the opening section. Again, the limits are identified by reference not to profits, but to the subject matter of the insurance, which is the commodities, A, B, and C. Hard commodities, soft commodities, and energy commodities. And then you have Shipments Clause. All shipments are covered under this contract, and it's basically for transit. This is where you take goods from one place to another. Storage risks. These are goods in store. And it's a longer clause, goes on to 367. And again, it closes by referring to the subject matter and the insured. Now, then we have the transaction premium clause at the bottom of page 367. This is the TPC. Here, the clause is sandwiched between, well, firstly, it's included within section 1. Section 1 identifies the subject matter as the interest. The interest is defined as the commodities. There is no separate definition or designation of the subject matter by reference to profits or any other financial loss. So as I said, the TPC is sandwiched between two clauses. The storage risk clause, which is a physical loss or damage cover for goods held in store. The clause which follows is the basis evaluation clause, which again is a valuation provision to identify how much the insured will recover in the event of physical loss or damage. So the TPC, I quite accept, doesn't in turn refer to the requirement of physical loss or damage. But what it does say is that the underwriters note and agree that in respect of any transaction, it's hereby confirmed that the insured is covered under this contract for the transaction premium that the insured would otherwise have received and earned in the absence of default on the part of the insured's client. So here, just looking at those words, the confirmation of cover is, I submit, a supplementary cover. It has to be understood in the context where the subject matter is defined as goods. Now, the response of the clause, the clause then defines a sale price. It then defines default, and I should read default out. It means a failure, refusal, or non-exercise of an option on the part of the insured's client for whatever reason to purchase or repurchase the subject matter insured from the insured at the pre-agreed price. Now, of course, the judge put a lot of emphasis on the words for whatever reason. But I say that just means the reasons or the motivations behind the client default. It doesn't remove the requirement that this clause provides cover as it is understood only in cases of physical loss or damage, because the subject matter of the insurance is goods, not profits. Then they have a pre-agreed price, again, the amount for which the the insured's client had agreed to purchase or repurchase the subject matter. And then we have the transaction where any transaction where following a default, the insured sells the subject matter insured to the applicable exchange. And I'm going to come back to that, it's important. And then the transaction premium, which is the difference between the pre-agreed price and the actual sale price. So if the bank had agreed a price of $100 with the client and the client defaulted and didn't pay it, but the bank then sold it on to someone else for $10, the difference would be $90. That's how the premium is identified. And then you've got the basis evaluation provision. Now, the basis evaluation provision is...
So what is the effect of this, if you're right?
The effect of this is if there's a physical loss or damage, and this is to be read with the basis evaluation clause which follows, it is if there's physical loss or damage of goods, bearing in mind that's the subject matter of insurance, the amount which is recoverable by the insured under the policy is to be defined either by the basis evaluation provision or the TPC, but the latter in the event that the requirements of the TPC are satisfied, which is where, for example, the goods are lost or damaged, and as a result, the client fails to pay for them, doesn't reacquire the goods, and the insured sells them on to someone else. So, for example, in the example I gave before, that might be a $90 profit.
As the judge points out, if they're a total loss, he wouldn't be able to sell them on to anybody else, and therefore the TPC wouldn't bite.
Well, that's a very good question, my lady, if I may. Firstly, for two reasons. The first is this. If it's a total loss, it's by no means clear that there's nothing to sell, because most total losses are constructed total loss. And there's always a residual value in most cases in a constructed total loss. I mean, that is the case. For an actual total loss, which is much rarer, even then, unless they're completely and utterly destroyed or irretrievable, so for example, at the bottom of the sea, or they're blasted to smithereens, if, for example, there still may be a residual value. So, because they may cease to be the thing of the kind insured. In most cases, it's a CTL. But the curious thing about that point, is the second point, is why does the TPC only cover, if it's a trade credit loss, what it's really getting at is a default by the insured's client to pay for the goods. Why does it matter if the bank sells or doesn't resell as far as a trade credit insurance is concerned. Why would that matter? In most trade credit insurances, what happens is the person who's, if you like, the creditor, doesn't get paid the debt and then is able to recover from the insurer. Whether or not the insured can or cannot mitigate the loss by, for example, selling the goods to someone else is an irrelevance.
Well, it benefits the insurer because it means he has to pay less.
Yes, but why would the insurer, or indeed the bank, want an insurance, or be prepared to provide an insurance, which provides no trade credit loss where there's a total loss? It doesn't make sense. Why does it
Sorry, I
matter?
thought that was a point against you, not for you. On your reading of this, if there's a total loss, you're not covered. On the other reading, they are.
Sorry, I fully accept if there's no resale, if there's no sale for whatever reason, whether it's because the goods were a total loss or because they just can't be resold in the market because no one wants them, doesn't matter, then the TPC won't respond. But the insured in those circumstances will still have the benefit of the basis evaluation clause.
And he doesn't need the TPC anyway, because he'd always have the basis evaluation clause.
Yeah, but the
It doesn't give him any advantage.
It does, because it gives him a higher measure of loss, a higher measure of indemnity. It's intended to provide what the basis evaluation clause says, and it's page 368, so it's the clause immediately following the TPC. The market value at the date of claim, provided the market value shall be no less than the market value is used at the date of purchase. So that's the governing provision. And then it says, for the purposes of this, the market value is defined as the published exchange price or any other price stated in the underlying purchase contract, call option contract, or any other document relating to the purchase. Now, what this means is the value which is being insured under the basis of valuation clause is the market value at the date of purchase or the price identified in the contract.
Whichever is the higher?
Under which, yes, either doesn't matter, because if there's a designation.
Well, it's got to be whichever is the higher.
Well, I don't think it says that. I think it says if there is a price stated in the underlying purchase.
Well, it may make a difference because this bank's business is to buy the goods at a discount, because the whole purpose of it is to sell it back at a profit, and that covers the cost of the repo,
Correct.
the finance. So under the basis evaluation clause, let's say that the goods are in a warehouse and they're destroyed. It's either what the price would have been on the exchange at the date that they purchased them, which ex hypothesi will be higher because they're buying it at a discount to the market price.
Yes, well.
So the question I posed to you actually has a practical effect.
Well, for the purpose of my argument overall, I don't think with respect, I don't think it matters. But I'm happy to opt for the whichever is the higher.
Right.
But the important thing about this clause is the market price is defined by reference to the value at the date of purchase or the amount identified in the purchase contract or option. So it's concerned with the price at which the bank acquires the goods, essentially. The TPC is concerned with the pre-agreed sale price. This is the price at which it will sell the goods back to the client, which will necessarily be a higher price. And of course, therefore, it's going to be covered for a higher degree of loss because it represents its lost profit, the difference between the purchase price and the sale price.
Depends on the movement of the market.
Well, in relation to that, it becomes a bit more complicated because there are a number of different transactions. Some were hedged against market movements. But in this particular case, we're concerned with goods which were of poor quality to begin with. So the goods were of poor quality once they were handed over by the client to the bank. So this is even so by the time when the bank acquired the interest, which was when the policy cover starts.
It paid over the odds for them.
Yes, and also, if you like, the seeds of the loss were already sown. So there is a very real difference between the basis evaluation provision and also the TPC. The basis valuation covers the value at the date of purchase.
You would would expect, if that were the intention of the TPC, for it to be under the basis evaluation clause. You'd expect the basis evaluation clause to say, where's the market value at the date of the claim, and this is how it's defined, or alternatively, if higher, the market value or the pre-arranged price with the assured, if that produces a higher amount.
Well, I mean,
It doesn't.
Well, they're next to each other.
Yes, but they're not in the right order with respect.
Well, it doesn't. I don't
You'd
think.
expect them to be the other way round under the heading basis evaluation.
Well, with respect, my lady, I mean, for what it's worth, the basis evaluation clause has already occurred once in the opening section.
Yes.
It's repeated here.
Well, the TPC is also repeated. Isn't it?
Later, not at the opening
18,
section.
yeah.
We've had there's an embarrassment of riches for number of times these clauses are duplicated. But but what I would say is I don't think it does matter about the order. What the whole point of these two provisions, the TPC and the basis evaluation clause, is to identify the measure of indemnity. The latter by reference to the purchase price or value, the former by reference to the sale price. The TPC covers additional profit provided the conditions are met, which is default by the client, a pre-agreed sale price, and an actual sale into the market.
And the one condition that is not spelled out, but you say should be read into this, is loss or damage, physical loss or damage.
Yes, but in the same way as if you look at the basis evaluation provision, it doesn't refer to physical loss or damage at all. So, just pausing here, we're still in section 1, which identifies the subject matter only by reference to the goods, not by reference to any profits. The provisions come up until the transaction premium clause are concerned with physical loss or damage, nothing else. We've got the TPC, which is obviously the clause in dispute. Then we've got the basis evaluation clause, which provides a measure of indemnity, and we say it applies only, as with the TPC, only to cases of physical loss or damage. And then we move on to proof of goods. Again, what the proof of goods states, underwriters agree that in the event of a claim arising hereunder, the relevant purchase contract of the insured, is the contract from which it bought the goods from the client, relating to the claim, together with the presentation of the applicable transportation document, storage report, and any other relevant documentation, as set out in the purchase contract, shall be evidence of proof of the existence of the goods and the unimpaired physical condition at the time of purchase. So here, what's important is the physical condition, making sure that the goods are in good condition and exist at the time of acquisition.
It gets around the problem that was encountered in the decision of Mr. Justice Cranston, which is where the fraudster gets you to insure goods against certain losses and the goods don't exist in the first place.
Well, it says it shall be evidence of proof. It doesn't say it's conclusive evidence or binding evidence. It just should be evidence. But it's still what's important. So it doesn't necessarily get around it. You can still disprove. I mean, if the goods don't exist, so if you've got a classic warehouse fraud, my lady, and the goods don't exist, and you've bought goods which don't exist, you're not going to get cover under this policy on cargo. Because that just doesn't happen. There's a different type of insurance to protect you against that. What's important is you have to demonstrate you had an insurable interest in goods which exist at the time of the loss. So you're not going to get around that problem. That's not going to be covered. But what the important thing about the proof of goods clause is the focus attached to the existence and the condition of the goods, which is relevant to loss or damage. Then you've got the missing goods provision, which again deems where you've got the subject matter insured. Again, the same phrase, and the word subject matter insured is plastered throughout this section, including the TPC, where the subject matter insured is missing and is deemed to be an actual total loss. And that's equivalent to section 58 of the Marine Insurance Act. And then you have the attachment provision. Well, and I'm now looking at page 369. So it says, subject to any other provision of this contract, the contract attaches from the time the subject matter insured becomes at the insured's risk or the insured assumes an interest in the subject matter insured until such time as the insured's interest in the subject matter insured ceases. So you need goods, and you need the insured to have an insurable interest in it. And you saw the definition of insurable interest in Section 5, subsection 2 of the Marine Insurance Act. So basically where the insured would be prejudiced by its loss or damage, or will be benefited from its safe arrival. And then you've got the institute clauses, all of which are really geared towards, as Mr. Justice Coleman said in 3A Chile, towards physical loss or damage. And then you've got a number of other provisions, which I won't go through at page 369 and 370, for example, dealing with seller's insurance. But it's 371 we then come to. Here, we've got a rating schedule. This is premium. And you've got a premium in relation to, there's different premium for hard commodities, soft commodities, and energy commodities. And I know if you look at hard commodities, they're looking at transit and storage risks, whether against war perils or all risks. And they're all percentages of the value insured, or the limits insured.
I mean, this is all in section 1 of the policy.
Correct.
Which concerns conditions, subject matter insured.
Goods.
Goods.
Yes.
But there's section 4 as well.
There is section 4, but why this is important is you have, and again, for soft commodities and energy commodities, you've got the same sort of rating approach, different figures, but the same approach. Now, why it's important, just pausing here, if I may, before I go into the other sections, is that you've got a policy which clearly designates the subject matter insured as goods and nothing else. Even the TPC refers to the subject matter insured, and that's defined as the goods, nothing else. There is the limits which are applied only apply to the goods insofar as they're insured as the subject matter insured. There's no limit referred to elsewhere in relation to any other type of insurance which might exist. There's no separate premium rating exercise or premium applicable to a pure economic loss or profits insurance. And that what is important is there's no identification of profits as the subject matter insured. Now, the only way you could find that there was such an identification of profits as the subject matter insured is to do so by reference to the terms of the clause itself. But the terms of the clause itself actually use the phrase subject matter insured, and that only means goods, it doesn't mean anything else. So my lords and my lady, I'm going to go into section 2 of the policy, which is at 372, which is general conditions. And there's largely, these are include definitions. You'll see in paragraph 7.3 the due diligence clause, which requires the insured to exercise due diligence following the occurrence of a peril in relation to the subject matter insured. You've got, I'm going to move on to page 375. The clauses 10 and 11. You've got goods insofar as they're purchased by the insured on FOB, CFR terms or CIF terms. And then we've got clause 13, which is page 376. Here,
does 13.2 apply in circumstances where the goods themselves not lost or damaged, but the conveyance is?
Yes, I think that would, well, if it sinks, obviously, the chances, I mean, yeah. But if it's stranded, then I think that the goods could still be physically sound.
It could be a fire and it could get them off.
Yes, and similarly on the, if you look at the 13.4,
emergency.
Yeah, 13.4 is something insured in whole or in part in emergency. So the goods actually may be fine, but that goes back to the point I was referring to before. This is a special charges clause, which is not unusual in cargo insurance, because when you're dealing with goods in transit, unless the goods arrive at their destination, you may have what's called a total loss of the adventure. That's a physical loss. And so the whole idea is to get the goods to the destination. So it is, in its true sense, a supplementary cover, because it's designed to prevent a total loss occurring.
What about 19?
I'm going to come to that. If I may. I was going to take it in order, but I'm happy to go to 19.
No.
So clause 14 is the return delayed or refuse shipments provision. And this is, again, where these shipments are delayed or returned for any reasons. All this basically provides they can continue still to be covered by the policy. So that doesn't really add a great deal. Then you've got removal of debris, paragraph 15. Then you've got 16, which is the fraudulent documentation clause. I did say my final heading, if you like, would be other provisions of the policy. But as I'm going through the policy and I am trying to abbreviate my submissions to assist the court, I'll deal with it now. So it's the final topic which I'll deal with now, because there are 3 clauses which belong to that. And it's fraudulent documentation, clause 16. And here, what is clear is this is a provision which is aimed at physical loss or damage, nothing else. And you can see in paragraph 16.1, the underwriter will accept exchange and non-exchange warehouse receipts, warrants, or any other approved exchange warehouse applicable to this contract, and documents evidencing ownership of the subject matter insured as proof of the existence and unimpaired physical condition of the subject matter insured and of the insurer's interest in subject matter at the time of issue of such document or at the time the subject matter insured became at risk of the insured. If a document is stolen, lost, or misappropriated, and such document is fraudulently converted such that the insured suffers physical loss of the related subject matter insured, or the impairment of the interest in the subject matter insured, such a loss shall be recoverable hereunder. Now, just pausing there, firstly, the policy refers to suffers physical loss. So that's a requirement of physical loss. This is not a provision which is aimed at financial loss alone.
Well, it's separate from 16.1. The $64,000 question is whether 16.1 requires it.
Well, so it doesn't because of 16.2. So remember, it's not conclusive evidence. We'll accept it as evidence. But 16.2 is important because 16.2 then goes on to refer to the impairment of its interest in the subject matter insured.
Yeah, but that's additional cover. That's separate from 16.1. The real question is whether 16.1 cures the problem that was identified in the earlier case law about whether or not you can have cover for a situation where the goods don't exist.
Well,
it may or it may not, but the intention plainly is to cover that situation.
Well, I don't think what 16.1 is not going to do is you still need, as by reference to the attachment provision, you need to have goods in which there's an insurable interest. And when we talk about the impairment of the insurable interest in goods, you're talking about, for example, damage to the goods as opposed to loss of the goods. That's why the word is impairment. But what you're not talking about is pure financial loss. It's not what it's getting at. But if my lady were right, and this clause is really aimed to basically protect you against the notion that you have there are goods, and they're not re-delivered to you, for example, from store, and all you've got is evidence that the goods themselves are subject to a particular document. Then that will deal with a very, very particular circumstance. But it's a deeming provision which achieves that end. But my submission to you is that that's not what this does. The insuring provision is 16.2, not 16.1.
16.3 is a bit clearer, isn't it?
So the insured is indemnified. Well, it's going to come on.
Direct financial loss, including by reason of the impairment of the interest, so not limited to, arising by being supplied with a counterfeit document or a fraudulently altered document.
Well, the you can have a direct financial loss suffered by the loss of the goods or the impairment of the insured.
That's not what this is aimed at, Mr. Eggers.
Well,
Including.
I'm sorry, my lord.
Including.
No, I see that. But what this is getting at is firstly a very particular problem, which is fraudulent documentation in a very specific setting. But when it refers to physical loss of subject matter, that is talking about a physical loss of goods. And when it refers to an impairment of its interest in the subject matter, that still refers to a physical loss or damage, because it's the interest in the goods which have to be prejudiced. And that's what's relevant to a property insurance. Now, I see when 16.3, when it says for direct financial loss suffered by the insured, including by reason of the impairment of the insured's interest in the subject matter, arising by reason of the insured being supplied with a counterfeit document or a fraudulently altered document, then I can see that it might be said that if the goods don't exist, if that's what the issue is getting.
You lay out the money for a cargo of cocoa beans which are supposed to be in a warehouse, and the cocoa beans have been already sold to somebody else, and therefore there's no possibility of selling them to this particular insured. But the documents are fraudulent and suggest that they've got title to the cocoa bean. It's covered under 16.3.
Well, let me. What is clear is first the words impairment of the insured's interest is a physical loss or damage wording, but I appreciate the wording including is used.
Yeah.
But if this is intended to provide cover for non-existing goods, so for example, as my lady says, if you purchase a bill of lading or a warehouse warrant relating to goods which is fraudulent, but the goods are not there, or you purchase goods belonging to someone else, so you never acquire an insurable interest, then it is, on one construction I can see that it might cover that scenario, but it's a very limited scenario. But that's not what this clause is getting at. It's really getting at where there's loss or damage caused by a fraudulent documentation. So it could be that your goods are sold to someone else, or it could be, for example, someone's created security interests in your goods by virtue of documentation. And
it's an extension to the policy to cover a situation where there is no physical loss or damage to the goods that you bought. It's as plain as a pikestaff, or it seems to me, with respect, that it's absolutely plain. Now, that may not hold your argument below the waterline, because it uses very clear language, and clear language is needed to extend the policy. So I don't know whether it takes the argument much further or not, but I think it does strain credibility to suggest with respect that this doesn't cover a situation where there is no physical loss or damage to the goods.
Well, let me put it this way: if the purpose of the clause is to basically provide non-physical loss or damage, financial loss, it does so in a particular way. Yeah. It does so by deeming the goods to exist and deeming the insured to have an insurable interest in it. Because paragraph 16.1 says that the underwriters will accept these documents evidencing the ownership of the subject matter and of the insurable interest. So it's actually, in effect, it might create a financial loss insurance, but it does so by assuming that it's actually that the goods exist and they are goods in which they have an insurable interest. So even though, in effect, it may create a financial loss insurance beyond the physical loss or damage, it does so by deeming those goods to be in place. And that's a very different, very incremental type of cover. But I was going to move on, my lady, and my lords, to the clause 17 is I'm not sure it would need to detain us. And then clause 18 is a container provision, which I don't think I need to deal with, other than the fact that it refers to the subject matter insured, as always. And then business contingency cover, which I think my lady raised a query about earlier, which is cover against all costs, expenses, and losses incurred by the bank as set out in this clause, including but not limited to any premium or profit element that the insured would otherwise have earned but for the delayed delivery of the subject matter in the related futures month.
That doesn't necessarily require loss or damage to the goods either, does it?
No, well, on one construction you could say that it doesn't, and also what it's really getting at is delayed delivery. But this goes back to my general point before when we considered forwarding expenses and special charges. It's part of the cover which you would accept for a potential loss of the adventure.
Well, I can see that if there's a marine accident and as a result of that the goods are held up while you're waiting for a transshipment from the port and therefore they cannot be delivered to the exchange on the relevant date, then this will cover it even though they may not be physically lost or damaged. And you say, well, that's all part of the perils of the adventure and therefore it's inherently connected with
Yes.
a marine policy. It's not confined to that, though, because it doesn't say that the delayed delivery has to be as a result of the frustration of the adventure or anything connected with the frustration of the adventure. Simply has to be a delayed delivery of the subject matter insured for whatever reason to the exchange or the futures exchange.
That's true, but what this clause is really getting at as well is providing cover for delay of the goods. And what's interesting about this provision is 19.3, where any declaration under clause 20 is to be recorded in accordance with the relevant contract terms and conditions and the premium to be calculated at 40% of the cover rates.
So you get an extra premium for that.
So this is a supplementary cover which might provide financial loss insurance in one sense, which is connected to the adventure. But here you've got to do two things to get this cover. One is there's got to be a declaration, and secondly you have to pay a premium of 40%.
Three, actually. There's got to be no previous losses which would be collectible. That's 19.4.
Yes. So you're quite right, my lady. Now, it's remarkable that the TPC clause which is said to be a trade credit insurance, of that nature, which ensures on the judge's construction and my learned friend's constructions, any trade credit loss, as long as there's a default, is not going to be, is insured without any specified limit, without any specified declarations required, and without any additional premium being paid. Where you've got this, what I regard as a more modest supplementary cover under clause 19, where you do have a requirement of a declaration, and you do have a requirement of an additional premium. Now, on my construction, that tension disappears.
Sorry, I didn't hear that.
On my construction, that tension, that oddity disappears. Because in my construction, the TPC clause is one means of measuring the indemnity available in the event of physical loss or damage. That's it. And you know from the rating schedule and the limit clause and the declarations provision that the cover will respond in accordance with those terms. But on the learned judge's construction, this is a much more free-ranging trade credit, pure economic loss cover with no separate limit, no separate declaration requirement, and no separate additional premium required.
Was there no factual matrix that made it perfectly clear what the bank was aiming at?
Well, the factual matrix is as recorded by the judge, and I don't think it demonstrates the bank's intention, if that's my lord's question.
Well, I'm just thinking about what the judge did say about that. I haven't searched for it. But,
Well, I allow my learned friends to refer you.
Without Miss Claire will tell us in due course. But, I mean, the idea that it is just one means of measuring the indemnity where there's physical loss is pretty difficult to reconcile with the wording of the clause and the fact that it lives in section 4.
Yeah, but you still have these other problems, my lord. I mean, bearing in mind, and just going back to the factual matrix, this is a trade credit insurance of this nature is unprecedented in this market. This is not an insurance.
Well, lots of things are unprecedented, and when they're unprecedented, they sometimes come before the Court of Appeal and the Commercial Court. It doesn't mean it didn't happen.
No, but this is an insurance where the cargo underwriters, who don't have expertise or the relevant equipment,
They probably wanted the business.
It's a soft market.
my lady, the soft market is a factor, but I don't think regarded as an important factor.
Maybe a
The
very
soft market
powerful insured.
I
He
beg your pardon?
wanted the business.
I'm sorry, my
I
lord.
mean, you know, this is sort of argument without. I mean, you know, we've listened very carefully to your construction, your interpretation points, which, if I may say so, are points. I understand those. But saying never before in the history of the world has there been a contract like this doesn't get you anywhere, because obviously we wouldn't be here if that weren't the case.
Well, I think the way I like to put it is this, my lord, and I do appreciate that I'm trying my lord's patience, and I don't mean to.
I'm not trying my patience, Mr. Eggers. I just require the argument to be directed at the issues in the case.
Well, I'm trying my best to do that. The important thing here is you go to a cargo insurer who operates in a particular market, of which the brokers and the insurers are both specialist participants. They take out a cargo insurance. There is a TPC clause, and I'll come back to Section 4 in a moment, but there's a TPC clause in Section 1, which comes under the designation of the subject matter as cargo or goods.
I mean, you might have, if I may respectfully say so, a much better case if the clause only appeared in Section 1. But
Well,
it doesn't. And I mean, I don't recall immediately what the judge said about that. But,
Well, I don't think anyone took the duplication of the clause itself as. Well, maybe I'm. Okay, well, I won't say.
But I'm just going to search and I'll find out.
Well,
what he
the
said.
judge did go into some detail about the circumstances in which first of all, it was inserted in one place and then it was inserted in another.
Yes.
And it eventually settled itself into both Section 1 and Section 4.
Correct.
And there was some debate, I think, as to where it properly lay, having been scratched on the endorsement. But
Yes,
Well,
he went on about it at great length, actually.
302.
Yes.
But the endorsement, of course, was only agreed by the leading underwriter and it wasn't binding on the following market.
yeah,
And indeed, the judge also found the following market weren't aware of the endorsement.
well, that was in 2015 when it was aimed to be put in as part of the preceding year's policy.
But as my lord said, if I may say so, entirely on point, at Section 3, paragraph 302, he said one of these locations was a separate Section 4. This was, in my view, the clearest indication that the coverage provided by the TPC was standalone coverage not linked to the need for physical loss or damage or the operation of the perils covered by the other non-PLOD add-ons.
I am going to come to Section 4. I did promise you I will. I will. But
I mean, we don't need to come to Section 4 because Section 4 is simply the same wording in a different section.
Yeah, but I'm trying to progress my way through the policy.
No, you carry on.
Okay. So I think the point I was trying to make before is this, and I appreciate my lord's comment about it doesn't matter if it's an unprecedented form of cover. But what I would say is this, that this is a cargo insurance where on the judge's construction and my learned friend's construction, there is what's said to be a trade credit loss, pure economic loss cover under the TPC. It is remarkable, firstly, that that construction could be held or justified when one considers that this is a cargo insurance policy where all the provisions we've looked at so far, with, I accept, certain supplementary extensions of cover, which we've also considered.
Well, that's your problem, you see. If there hadn't been any supplementary extensions of cover, you'd be in a more powerful position to be able to say, well, everything centres around physical loss of or damage to the goods. But you can't say that because there are special provisions, which we've looked at, which cover pure financial loss, which are not contingent on the loss or damage to the goods, or indeed on there being some sort of frustration of the marine adventure.
Well, but the supplementary covers we have considered, which are special charges clause, the business contingency cover, and the like, are clauses where, and I put the fraudulent document clause to one side because I've already made my submissions about that. But as far as those clauses are concerned, I do think that they are providing supplementary cover, which is closely related to the risks which are normally insured under a cargo insurance policy. But even with the BCC, the business contingency cover, clause 19, for that extension of cover, you get an additional premium. But if the intention of the parties And that's what I'm asking objectively. If the intention of the parties had to be engrafted an entirely self-standing, pure trade credit loss provision, insuring provision in this policy, it just doesn't make sense why there is an absence of a limit, a declaration process, or indeed an additional premium.
Well, what it means is that your client's made a bad bargain. But you can't rewrite the contract in order to reflect the fact that a bad bargain was made.
I'm not trying to rewrite the contract. Well, my ladies may say I am, but that's not my intention. My intention is to try to construe the contract.
Well, you can't construe the contract because a bad bargain was made. You can say, if it was intended to extend the policy, you'd normally expect that there would be a quid pro quo in the form of a premium. And I take that point entirely. But there isn't always. There is with one of the clauses you've shown us and not the others.
Well, let me ask you, my lady...
Anyway, let's not get involved in too much debate. You have an argument to pursue. Let's pursue it.
I'm sorry, my lord. I didn't mean to continue the
Let's just pursue the argument.
So then we come to section 3, which is the additional cover, confiscation, expropriation wording on 379.
Yeah.
Now, this is providing cover for... you can see in 1.2, loss or damage to the subject matter insured directly caused by confiscation, moratorium, seizure, appropriation, expropriation, requisition, and it goes on, willful destruction under the order of any government, etc. And then the word deprivation, which is also used in...
Kind of political risk cover, right?
This is a political risk cover.
Yes.
Yes.
Do you normally amalgamate political risk with cargo?
You do, because, but this is all physical loss and damage. It's not financial loss. So what normally happens, my lord, for example, in insurance on ship, you'll have institute war and strikes clauses which will insure against political risks, which include the risks referred to, confiscation, deprivation, etc. But that's a physical loss of the vessel because someone has got your ship, and so once it becomes a total loss, it's gone completely. This is no different. This is extending the cargo insurance to include that, and the reason it needs the extension is because the institute cargo clauses war, which are incorporated, don't provide political risk cover unless they're in a war setting, whereas this is political risk cover outside a war. So my lady's looking to the sky, and the reason for that is, war risk cover on hull provides political risk cover irrespective of whether it's in a war setting or not. But the institute cargo clause is war.
Because normally if you want war risk insurance, it works on the basis that you don't go into a war zone, but you declare that you're about to enter one, and then you have to pay an extra premium.
Or here it's in place. There's actually war cover here. For all the goods under the policy. There's a separate rating schedule, as long as it's declared. But that's good.
Isn't that somewhat unusual in a marine cargo policy?
No, it's not. For an open cover of this nature, it's not unusual. To have both all risk cover and war cover. But war cover in the cargo market is limited to a war setting. So when I say capture, seizure, arrest, detainment, etc.
It's wider.
That's only in a cargo policy. That's in relation to war risks. But in a hull policy, it's unlimited. It's not related to war risks. It's just wider, as you say. And this is the purpose of this provision: is to extend that physical loss cover. This is not insuring anything other than physical loss or damage. Because it says so. Because it says physical loss of or damage to the subject matter. And then it defines deprivation to refer to loss of use or possession, but that's just the definition of a total loss. And then, of course, you've got section 4, which is the transaction premium. Now, you're right, this clause is repeated, as a number of other clauses are repeated throughout the policy. I should also, and
this has a whole section to itself.
It does.
And it talks about that it's in the insured being covered insured under this contract for the transaction premium that the insured would otherwise have received or earned in the absence of default on the part of the insured's clients, the default being a failure to repo.
Correct. And that's the terminology used in the clause.
Yes, so it's all about the precise nature of the transaction that this policy is aimed at, which is the repo financing of cocoa.
Well, what this clause does, I would say that it is located in section 4, but it does. You'll have the same clause located in section 1.
Well, forget that for a moment. And let's try and, if we take it at face value, it says it's confirming coverage in a separate section of the policy. Why should it not be read at face value as providing additional coverage in respect of what it says it's providing additional coverage for, namely the transaction premium that the insured would otherwise have received or earned in the absence of a default by the insured's client, which is the underlying nature of the transaction that the parties knew the bank was engaging in.
But the reason, my lord, is because this clause, this section, doesn't identify or define the subject matter. That's only defined in one place. And that's section 1, which is cross-referred to in the opening section of the policy. Now, my lord may remember in the Frio Chile, the decision of Mr. Justice Coleman, that the subsidy was the one section which didn't have the word interest identified. And he relied upon that fact, but also the fact of the identity of the perils in that section, to say that the subsidy itself wasn't the subject matter of the insurance. Here, even though the transaction premium, if I just focus on section 4, as my lord has asked, and forget about its repetition in section 1, it refers to the subject matter insured itself, and there's only one subject matter insured, which are the goods. There's no attempt to identify a separate subject matter at all. In the same way as the clause.
Why does it need to?
No, it does need to.
It doesn't need to, because if you go back to business contingency cover under 19, if you're right, then the costs, expenses, and losses incurred would have to be defined as separate subject matter.
No, because if it is a supplementary cover, which is, for example, a sue and labour clause is a supplementary cover. It's included in all marine policies, but it can be operated as a pure financial loss cover. But you don't.
Yes, but I think if I may say so, Mr. Eggers, you're trying to prove too much. Of course, this is about the cocoa, which is the subject matter insured as defined in section 1. But the insuring clause within section 4 is what I've read out to you now twice, and I won't read out to you again. And it makes no mention of the subject matter insured. Instead, it says expressly that you're covered for the I'm now going to do it again, what you're covered for. Now, that's the point. And it's all very well to say that Mr. Justice Coleman, who was dealing with a quite different case in a quite different context, found that an ancillary clause did not refer to an interest in the goods. But this is not the situation here. There is a clear, separate section, which obviously lies very easily with the factual matrix and the background to the insurance, because this is what the bank was doing. I mean, we know what the bank was doing. We've had it described to us 100 times. And what it was doing gave rise very easily to a request for this additional insurance. And I just don't, at the moment, I mean, I see, if I may say so, the attractiveness of your argument. I see that when you, but it's often the case with insurance that it's not done in the most logical or sensible way, and that things don't completely hang together, as Lord Thomas said in the quote that everybody loves to quote back to us. You know, it's a slip, it's done quickly, it's, you know, they add things in that don't quite fit, and they add it in twice, not once, and so on. We're a court. You know, we're trying to do the best we can to give meaning to what the parties intended. And to say that the first 4 lines can be utterly disregarded because of however many other things is a big thing to say.
Well, big or not, I do say it.
I know you do, Mr. Ferguson, with great eloquence.
Well, that's very kind of you, my lord. But the transaction premium, I mean, it does say, on my interpretation, the one I'm putting forward, is it's confirmed that the insured is covered under this contract. So when it uses that language, I say that means the cover is extended to include transaction premium in the event of physical loss or damage.
Yes, but the in the event of physical loss and damage is not the words used. And the words subject matter insured are used as you'd expect them to be used to actually cover the goods that will give rise to this loss, financial loss.
Well, I don't want to repeat myself too often.
Well, no, I haven't put that to you before, or any of the points I'm now putting to you. I've waited patiently to put these points.
Well,
you've been through the entirety of the policy.
Well, what I do say is this: that if this wording were put into a single sheet of paper by itself, without any other context, without any cargo insurance, then of course the absence of a reference to physical loss or damage would be significant. I agree. But we're in a different. This is a different policy. This is a different contract. This is a policy of cargo insurance written in a particular way. My lord has already indicated it's a slip which is thrown together, and it's thrown together to such an extent we've got a number of clauses, including this particular one, duplicated. Now, my lord has rightly, well, I say rightly, I mean, I understandably have said to me, well, it's in a separate section, but that doesn't mean you start ignoring the fact that it's also in section 1. Section 1, as I say, is a provision which is defined by reference to a particular subject matter insured.
But you have to look at the 5 sections of the policy. And the 5 sections of the policy have a certain discrete purpose.
They do.
Section 5, we haven't got to it yet, is about profit commission, broker's cancellation.
So that's nothing to do with subject matter insurance as such.
No, but it's a separate clause that
Yes.
you find. Section 3 is additional cover relating to compensation, confiscation, and expropriation,
For physical loss or damage.
which we've discussed. I mean, I understand that. I'm not trying to depreciate your argument by not mentioning it in every.
No, I'm not saying you are.
term.
I'm not saying that.
Section 2 is general conditions, which you find in every policy, not always at that point. And section 1 is the what you might call the standard marine cargo cover. And so you put in a section for one of several reasons, but the only one that one can see for putting in section 4 is because it's giving additional cover, and then when you read it, it says it's giving additional cover, so you imagine it is.
Well, I mean, what I would say to this court is that the duplication, in the fact that the clause is duplicated, you don't give priority, or indeed to the fact that it has its own section. You cannot ignore the fact that it's also in section 1. It is that's part of the clause.
I think Lord Hoffman once said that the same words used in a contract twice may mean different things in different places. In the case of Oxford County Council against Oxfordshire County Council, or something like that. But
well,
it's,
so if that were the case, of course,
happen.
that would mean my construction on the section 1 version of the TPC is correct. But I would go further and say my construction of both versions of the TPC, which, I mean, I would say, show no signs of being differentiated.
Well, what's the point in having section 4 then? What's it about? Why was it put there at all?
It's like all slips. Sometimes you wonder why these clauses are there. But what is undeniable, the clause is also in section 1. I mean, the question you've asked my
The answer to my lord's question is it's otiose, Mr. Donzakis.
But it could also, but which one is otiose? That's the question.
Well, on your construction, it's section 4.
No.
It's totally meaningless. It has no extra purpose to it. Because all you need in order to have an extended valuation calculations to put it into section 1.
Yes, but I think the court's putting to me the fact that actually the clause means the same thing in both sections.
Yes.
And so it's the same response to that point can be made
Well,
by
there's
me.
no point in having it in section 4 if it means the same in both sections.
But I could say that there's no point having in section 1 if it doesn't mean the same thing in both sections, because section 1 is important. And when I just look at the architecture of the policy as a whole, and I don't want to get lost down rabbit holes, because I'm in the sense of answering points which I know I've already answered numerous times, but that's not a criticism of the court, it's a criticism of me, I should make it clear. But the fact is that you have, as my lord started to outline, there are 5 separate sections with an opening section beforehand. The only section which purports to define the subject matter, not of the section, but the entire insurance, is section 1. And that definition of the subject matter, insured, is also cross-referred in the insured provision on the opening page of the policy. What section 4 doesn't do, and I appreciate it has its own section, section 4 doesn't identify or define or designate, to use section 26's terms, the subject matter of the insurance by reference to profits, by reference to transaction premium. It doesn't do that. Whereas section, and that's why
Why do you say it doesn't do that?
because section 1 is clear in its terms.
No. Why doesn't it do it, looking at it on its face?
Because all it does is identify what is covered, and I say that's an extension of cover in the case of physical loss or damage, and it defines it by reference to a transaction premium, which is defined in the clause itself. But in doing that, what it's not doing is defining what the subject matter of the insurance is, which is a separate requirement of section 26 of the Marine Insurance Act.
Well, surely the subject matter of this particular coverage is the transaction premium that the insured would have received if they'd not been default.
Well, my lord, if you come to the conclusion that section 4 on its own, as a matter of construction, identifies or designates the subject matter insured, that's a permissible way of dealing with the issue. I don't think it's the correct way, but it's permissible. I don't disagree with it. I don't say it's not heretical.
Not the correct way, but I'm not being heretical.
Yes. So I hope that's...
Goodness for that, Mr.
Well, I'm glad to reassure you.
Never been accused of being heretical.
But the important... So that's certainly an avenue open to you, and I accept that. But what I do say is that avenue would be mistaken where the policy takes a great deal of care to identify what the subject matter insurance is, generally, because sections 2, 3, 4, and 5 don't even purport to define the subject matter. Only section 1 does. And that's, as I say, the section which is cross-referred to in the opening section of the policy.
Remind me why it matters, because if in other cases you don't need to define the subject matter insured as being anything other than the goods, so you can have business premiums and so forth in circumstances where the goods are not lost and damaged. Why do you need to define the transaction premium as a separate subject of the insurance if it's something which is part of extended cover relating to the goods which you can recover as a necessary extension?
Because the other, what I would call more modest extensions of cover, are, if you like, part and parcel of insuring cargo in transit or in store. It's just part and...
But I think we've already demonstrated that they're not.
Well,
or at least some of them aren't.
Well, I don't think I necessarily accept that, my lady. I shouldn't be taken to accept that. I may appreciate that may be your preliminary view, but it's not what I've been putting forward to your ladyship. So if you look at the special charges clause, you look at the business contingency cover, that's not what it's getting at. The fraudulent documentation clause is a very specific extension dealing with a very particular problem associated with cargo in warehouses, for example, which is a particular type of fraud. But even there, it deems the cargo to exist, which is an essential part for any cargo property insurance. But when it comes to the transaction premium clause, it stands out as a complete oddity if it's a trade credit insurance. because of the factors I've already mentioned, and I'm loath to repeat them just in case. But it does. It's subject matter not identified. There's no separate premium rating for a far more extensive cover. No declaration process. No separate limit. It's quite remarkable. So the question is: are the parties to this contract, both brokers and insurers, brokers acting on behalf of the insurers, objectively speaking, likely to have intended such a exceptional extension, substantial extension of cover in the absence of those factors, and bearing in mind the nature of the cargo insurance market, which are the subject of particular findings by the learned judge? I say no.
Okay. Right. Well, let's move on because you've only got 29 minutes left.
Well, I think, I hate to say this, my lord, I think I'm going to please you because I don't think I've got much more.
I just wanted to be clear while I'm thinking about it that I shall expect the parties to move swiftly on if we go short on this part of the appeal to the other part of the appeal.
I understand, my lord.
This afternoon. We're not going to be rising and waiting for tomorrow to deal with the second appeal, which I thought was regarded by all parties as the first appeal, by the way. But don't worry about that. Don't rise to that.
No. Let me just check my notes before we go on. I think.
I mean, it would be helpful to me if you had 5 minutes.
Yes.
For you to identify in the judge's judgment where he was specifically wrong in your submission. I know that's a very eccentric way of dealing with an appeal, but sometimes the court finds it finds it straightforward when the advocate says, well, the judge got it wrong at this paragraph, and if he'd understood properly, it would have been a much better judgment. He'd have found the other way.
Well, my lord, I think the most efficient way of dealing with that, I think, is at page 504 of the core bundle, tab 19, which is a reference to my skeleton.
So, can I have the paragraph number in your skeleton?
Paragraph 12.
Thank you.
That's at least as a starter. They're the findings made by the judge with which we take issue. Just going through my notes, just to where else the judge, I think, erred. Firstly,
He must have erred in 302.
yes, I mean that's, if you like, one step along the way.
Okay, well, it may be not helpful in this particular case. It's just,
I mean,
I always think it's helpful.
if it were helpful, I could always provide to your lordship a list.
It's okay.
You make the complaint in paragraph 15 that the judge approached the factual matrix in the wrong way.
Yes, I mean, I'm not sure that's probably the most elegant use of language. I mean, the right way to approach, as I've already said, is you look at all the relevant aspects of the language and the context. As far as context is concerned, you look at the nature of the market, the background knowledge of the parties who are participants in the market, or the knowledge they ought to have had, as well as the commercial purpose of not just the TPC, but also the other provisions of the policy. And then you look at the entirety of the policy as a whole, because that's an important part of this exercise. And as I say, it doesn't matter. I mean, the judge approached it on the basis by saying, well, I've looked at the words, and there's nothing in the context which dislodges me from my interpretation of those words. But another approach might be you start with the context, and then you consider the words in the light of the context you've already identified. But it doesn't matter. It's because the process gets you to the same place.
It's an iterative process.
It's an iterative process. And, and then what that essentially means, if I may say so, is that as you go through each aspect of the context and language, you test your conclusion.
You check it.
Correct. And I don't think I'm not saying that's not the correct.
No, it's not contentious.
No.
I mean, it's the way we do it these days. And
I think
there's a limit to the number of different ways in which you can explain the process of contractual interpretation, which is why their lordships seem to have stopped accepting quite so many appeals on points of interpretation of contracts.
All right. I think the one point I wanted to make good in case that I had to make it good, which I may have sort of skated over, was just making good the point about in this Section 3 CEND, the confiscation clause, and why that means it only refers to physical loss or damage, nothing else. Firstly, it's the language, but it's also sections 57 and 60 of the Marine Insurance Act, which define a physical total loss as, by reference, not just to damage, but also deprivation of possession. I don't think I made that point before. So I think, my lords and my lady, I would say that as a matter of construction, the TPC clause provided a measure of indemnity, which is a loss of profits, defined as the difference between the pre-agreed sale price and the actual sale price, but only where physical loss or damage occurs. And I say that because the subject matter of the policy is defined as goods, not profits. That's confirmed by the fact that the TPC clause is located in Section 1. And the existence of the TPC clause in Section 4, I say, should not be taken as varying the meaning of TPC clause in Section 1, not least because the TPC clause in Section 4 does not identify or designate with reasonable certainty, as required by Section 26, that the transaction premium is a subject matter of this insurance. Indeed, the TPC clause on its own, in its language, should be understood, and objectively should be understood, as the parties intending to extend cover in the event of physical loss or damage to cover this additional profit. And if the clause doesn't apply, then of course the basis evaluation clause can be relied upon, which would give the insured a lower level of recovery because the TPC clause is defined by reference to the sale or the pre-agreed sale price, whereas the basis evaluation clause is defined by reference to the purchase price. Now, I submit that all of the other provisions we've considered in this policy are consistent with this construction. Insofar as there is any financial loss insurance which is not dependent on physical loss or damage, they are provisions which, by and large, are supplementary and part and parcel of the types of risks which are insured by a marine cargo or storage policy. The fraudulent documentation clause which we looked at is dealing with a very particular scenario. But even in that context, it is deeming the goods to have existed, and so operates on a deemed basis as a property insurance and nothing else. It's not a financial loss insurance, even though it may have the effect of being one. But you don't have that sort of mechanism used in the TPC. This was placed in the cargo insurance market, where this type of cover is not available, and it's not. And these participants in the market, as far as the underwriter is concerned, did not have the wherewithal to deal with these types of risks. And if it really were the case that you would intend there to be a transaction premium covered irrespective of physical loss or damage, firstly, you would expect the subject matter to be appropriately designated, which it's not. You would expect an applicable limit to the cover to be identified. It's not. You would expect a declaration process to be used. it's not. And you would expect an additional premium to be used, bearing in mind other forms of cover, which are more restricted, even though supplementary, attracted additional premium. Now, my lords and my ladies say, well, this just may be a bad bargain. But I say, no, this is more than bad bargain. These are factors which make it inherently unlikely the parties objectively intended that consequence. If I may, one moment. Yeah, so the one, my learned junior just reminded me that the judge did say paragraphs 296 and 297, and then again in 353, that the judge himself, I think, he says the language of the clause, as discussed earlier, should be given the same meaning wherever it appears in the policy. So he didn't distinguish its meaning depending upon where it was located. So when it was in section 1 or section 4, it had the same meaning. My lords, my lady, unless you have any further questions, then must finish.
Could I just ask one question,
Of course.
please, about your skeleton argument at paragraph 12,
Yes.
where you say that the judge interpreted the TPC to mean that it provided independent credit insurance cover.
Yes.
I'm not sure that he ever did, in fact, use that expression, and on one view, that might not be an accurate description of what he did find. Could you just, I don't mean now, but at some stage soon, point the court to the place where you say he found that?
Yes. Sorry, one moment, my lord. I'll look, my lord. My recollection, the words trade credit were certainly used.
They were certainly used in argument. I'm more concerned about what the judge actually found.
Yes, but what I would say is whether he used the words or not, the nature of the finding is where you have an insurance cover which pays out only on a default by a customer or a client.
Well, yes, but that isn't really this, is it? This pays out in respect of each transaction up to a maximum level of the agreed sale price. The difference between the value of the goods as they turn out to be and that agreed price, which is not, it happens to follow a default by the insured's client, but it's not just a default to pay a debt.
Well, I think on the judge's construction, I think as long as there's a default for whatever reason, I think it's the language used in the policy, by the customer, the cover would respond. The reference to the pre-agreed sale price and the actual resale price or actual sale price defines how much you get. It's the default which matters. And that if that's the right interpretation, well, I said I don't think it is, but if it is the right interpretation, that I would put that as a trade credit insurance.
All right, thank you.
Thank you, Mr. Hayes. Ms. Healy, you're going first.
Miss Savinclair.
Miss
yes.
Sinclair, sorry.
Right.
Being stupid.
Yes, my lord. So, by agreement with Edge, the bank is going to make the submissions in relation to the construction appeal, subject to any additions that Ms. Healy may want to make on behalf of Edge. The bank is going to make the running. So, my lord, in our submission, the judge was right, and he was right for the many reasons that he gave. This is a conspicuously detailed and conscientious judgment which rigorously applies the authorities in relation to contractual construction. Having done that, the judge concluded that the language of the TPC was clear, and also, importantly, that the underwriter's alternative suggestion that it was a basis of valuation clause was unsustainable. And that second finding is important too, because if there are competing interpretations of a clause, the court has to consider, by application of the principles of construction, which is the right one. And the judge said that the underwriter's candidate didn't wash. My lords, my lady, I'm going to make my submissions in support of the judge's conclusion under 3 headings. So I'm going to start with the words used in the policy, and I'm going to make the submission that the construction that the judge gave to the transaction premium clause itself is the only one that it can bear. And I'm going to say too that that is true as well when the clause is seen in the context of the policy as a whole, as it must be. So that's a twofold point about the narrow clause itself, and then secondly its context in the policy. Then my second heading will be the factual matrix. We say that the judge took the factual matrix properly into account. He took it into account from the start, as Lady Justice Andrews said, by framing the question, are the words of the TPC clear? That was applying Engelhardt. He then went on to give specific consideration to every one of the matters that underwriters now rely on. But ultimately, he held that the factual matrix and commercial sense considerations were not all one way, and that he didn't gain much assistance from them in construing the clause. What underwriters really want to say on this appeal, and what they would need to say, is that construing the transaction premium clause as the judge did leads to such an absurd conclusion that the parties must have meant something different. But there's no basis for that. And then thirdly, I'm going to deal with underwriters' new argument, not developed before Mr. Justice Jacobs, about the subject matter insured. Reliance on Section 26 is, of course, circular, because the Marine Insurance Act only applies insofar as this is a marine risk. But even if Section 26 is relevant or in some way a guideline, the section requires nothing more than reasonable certainty. It is, in fact, by way of anti-technicality provision. Reasonable certainty is rather lower than the question that the judge asked himself, are the words clear? And the question of reasonable certainty is to be resolved as a matter of construction by reference to the policy as a whole. See Mr. Justice Coleman and the Frio Chin. So, my lords, my lady, what we say ultimately is that however you frame it, however you dress it up, there's really only one question on this appeal, and that's whether the words used in the transaction premium clause create cover in respect of default, irrespective of physical loss or damage.
Well, Ms. Sinclair, I'm not asking you to say nothing, but you can take it relatively shortly.
Yes, thank you, my
I
lord.
think we have the...
Well, I will go through the points that I have, but I'm happy to be moved on.
Please do that.
By way of final introductory point, I do want to make it clear that we espouse all of the judge's reasoning on construction, including the discussion of the principles in paragraphs 175 to 178. And we say that he was right in paragraph 288 to distill from the authorities the proposition is that the purpose of interpretation is to identify what the parties have agreed, not what the court thinks that they should have agreed. English law doesn't rewrite contracts for the parties when they turn out to be bad bargains. So I come then to my first heading, which is the language of the policy, and my first submission, which is that the language of the transaction premium clause is itself clear and unambiguous. And the most convenient place to look at the clause is in section 4, page 308 of the hard copy bundle, 385 of the PDF. Paragraph 1 of the clause is, of course, the guts of it. Underwriters note and agree that in respect of any transaction, It is hereby confirmed that the insured is covered under the contract for the transaction premium that the insured would otherwise have received and or earned in the absence of a default on the part of the insured's client. Imagine that on its own, freestanding. No problem. It makes sense. It is an insuring clause. The language is that of coverage is covered. An insured peril is identified. Default. An insured interest is identified. The transaction premium. And to go straight to Mr. McDonald-Eggers' point on subject matter insured, my Lord Justice Voss, the Master of the Rolls, was correct in saying that the transaction here is defined by reference to the subject matter insured, because what this is doing is telling you that you get this cover only if you've made a declaration in relation to goods under this contract. So, as underwriters themselves say in their skeleton, this wasn't some sort of floating policy over the bank's entire book. You had to make declarations under the policy. But once you'd done that, you got this cover. So that's the headline point. Default, as I've said, is the insured peril, and that is defined, as you see there, as a failure, refusal, or non-exercise of an option on the part of the insured's client for whatever reason to purchase or repurchase the subject matter insured. As a matter of language, the words "for whatever reason" mean just that. The underwriter's construction means reading in a limitation, physical loss or damage only, which is not expressed and positively inconsistent with the language chosen by the parties, for whatever reason. But it gets worse. As the judge said at paragraph 259 of the judgment, this very concept of default is alien to the arena of physical loss or damage. And there are three aspects to that. The first is that, as the judge said, and as Lady Justice Andrews has put to Mr. McDonald-Eggers, it's immaterial whether there's a default if there's physical loss or damage. You've got your cover anyway if there's physical loss or damage. You don't need a default. The second point is that the language of default is alien and inappropriate where there's physical loss or damage. If a counterparty refuses to buy goods because they no longer exist or have been so damaged that they're commercially worthless, the counterparty is not in default. Under the contracts here, risk remained with ISTAR. It just doesn't work. Then the third point is that this clause is concerned exclusively and explicitly with the contractual position between the bank and its customer. The defined concept of default is founded on contract, not physical loss or damage. It means a failure, refusal, or non-exercise of an option to purchase or repurchase. That option's got to pre-exist. So what the transaction premium clause is not concerned with is maritime perils affecting the physical goods. It's just not what it's about. Finally, on the words used here and picking up some points that Mr. McDonald-Eggers made, there is nothing compressed about this clause. It is fully and carefully drafted. Second, agreeing to do something outside your expertise is hardly exceptional. It doesn't change the meaning of the words used. And third, it doesn't help to call this clause unprecedented. It was on any view. The expert underwriters were clear on that. To say it's unprecedented merely begs the question, what does it mean? So that's the language of the clause. Now let's put it into the context of the contract as a whole. And I want to start, please, a few pages back at page 362 of the hard copy, page 367 of the PDF. And turning here to the context of the contract as a whole, I'm really developing my submission and the judge's conclusion that the underwriter's alternative construction of the clause didn't work. So at page 362, you have the basis of valuation clause. This is in the preliminary section of the slip. It's common ground that this is the clause that would apply in respect of a physical loss or damage. The basis of indemnity is not simply open market value. It covers, and I'm now 5 lines down, any other price stated in the insured's underlying purchase contract, call option contract, or other document relevant to the purchase. 2 points flowing from that. The first is that when this policy intends a clause to provide the basis of valuation for insured goods, it says so. This is called a basis of valuation clause. It's directly contrary to this express labelling of this clause to suggest that another clause, not so labelled, is in fact a basis of valuation clause. Second, the transaction premium clause is surplusage. It is OTOs if it's confined to physical loss or damage. Mr. McDonald-Eggers repeated a submission that was made to the trial judge that the basis of valuation clause is confined to the purchase situation and the transaction premium clause about sale. First instance, it was put on the basis that the transaction premium clause was some sort of top slice to add to the indemnity. That submission was rejected by the judge at paragraphs 273 to 279, which we would ask you to read. The short point is that the basis of valuation clause covers the repurchase leg because it includes the call option, and that was the repurchase leg. The broader words relating to the purchase contract would cover anything beyond that. The judge described the bank's repo transactions at paragraphs 34 to 38, and he held at paragraph 275 that there was nothing unusual about the way in which the bank conducted its business, and that although underwriters might not have been aware of the details, they were broadly aware that the bank was conducting repo business. So, put all that rather more shortly, it says call option in this clause, so it's wrong to suggest that the transaction premium clause is doing something more than that.
Well, I think Mr. McDonald-Eggers' point was that the focus, certainly as developed before us, is that the focus of this basis of valuation clause is on the time of acquisition of the goods. So you're looking at the price that's in the underlying purchase contract from the customer, whether that contains a call option or not.
Yes, but that's mistaken to distinguish between the time of purchase and the time of sale, because these were repo transactions.
Exactly.
There was just one transaction.
Yeah.
So then, carrying on through the policy, we turn on to section 1 at page 367 of the hard copy bundle, 372 of the PDF. And at the bottom of the page there, we have, for the first time of asking, the transaction premium clause. And immediately after that, page 368, the basis of valuation clause. The question of the construction of the transaction premium clause is, of course, to be gathered from the contract wording and the surrounding circumstances. The Supreme Court reminded us in the FCA case that we have to ask what a reasonable reader of the policy would make of this. What a reasonable reader, looking first at the transaction premium clause and secondly at the basis evaluation clause, would not conclude is that the transaction premium clause is some sort of top-up to or supplement to the basis evaluation clause. As Lady Justice Andrews said, it comes before the basis evaluation clause, not after it. The clauses don't refer to each other. There's no cross-reference from one to another. And the language used in the two clauses is entirely different. No language of coverage in the basis evaluation clause. My Lord, I see the time.
Jolly good. We'll resume at 2 o'clock.
My Lord, before the court rises, can I just ask one question? There was an exchange of correspondence between the parties yesterday concerning the estoppel appeal. Does the court have copies of that? If not, I can arrange for further electronic copies to be provided.
I have. Yes.
Yes.
Very good.